560 The Answer.
Now, from the Signature Bank Studios. This is Chicago's Morning Answer with Dan Proft and Amy Jacobson on AM 560. The Answer.
Top of the morning, Dan and Amy. All right, we need expert opinion on this, other experts' opinion about what Trump could possibly do if he were to be convicted in Manhattan, that show trial in Manhattan. Mentioned this when we talked about it last hour. Mark Levin posted argument by a friend of his, a gentleman named Arthur Ferguson, who served as a law clerk to the late Chief Justice Warren Burger. And he argues that Trump could, if convicted, appeal to the Supreme Court for an expedited review of the New York trial court's decision. He argues, I'm quoting him, "The principal ground I would rely upon is the denial of due process by not informing Trump of the underlying federal crime he was alleged to have committed, the predicate crime that New York law requires to prove the New York crime. That is a kangaroo court. To try someone for a crime that they are not informed of is as serious a breach of due process rights as we can possibly imagine. The timing of the trial and the blatant denial of the fundamental rights can only be explained by an effort to interfere with the fair conduct of a presidential election, thereby, in effect, denying the American people the right to a Republican government. The Supreme Court warned that Bush v. Gore not be relied on as a precedent on the merits, but it can and should be relied upon as the Supreme Court acting to preserve American democracy from an imminent threat. Consistent with that is the refusal of the Supreme Court to grant expedited review to the immunity controversy at the request of federal prosecutor Jack Smith. The NY trial court represents an imminent danger to the fair and untrammeled conduct of a federal election for the most powerful position in America and the world. The Supreme Court has the power to act to protect our democracy, and it should. If a guilty verdict is returned, it should act right away." Well, that would certainly be an event, wouldn't it? And a series of unprecedented and largely unreal events. For more on one of the possible outcomes of the trial and potential avenues for redress by Trump, we're pleased to be joined again by Professor William Jacobson. He's a clinical professor of law, director of the Securities Law Clinic at Cornell. He's also the founder of LegalInsurrection.com and president of the Legal Insurrection Foundation, as well as the Equal Protection Project. Professor Jacobson, thanks for joining us again. Appreciate it.
Thank you for having me back on.
So what do you think about Mr. Ferguson's argument about the path directly to the Supreme Court for appeal if Trump is convicted?
Well, this is state court, so I don't see how you go from a state trial court directly to the Supreme Court. So maybe I'm just not understanding that process, but that's not the normal process. You would go to the state appellate court, and you go to the state court of appeals, which in New York State is the highest court. Your listeners may not realize the Supreme Court in New York State is actually the lowest court.
Right.
Why they do it that way, I don't know. So, and then you could go from the Court of Appeals to the Supreme Court. So you can go from the highest court of a state to the U.S. Supreme Court. And whether they take the case or not is up to them. But I don't personally see how you go directly from a jury verdict in a state trial court to the U.S. Supreme Court.
I didn't see it either, and that's why this is sort of novel and interesting. But he and this guy is obviously, a sharp legal mind as well. He argues that basically the court has a host of common law writs that were actually authorized as a general matter by the Judiciary Act of 1789. And I don't want to get too academic here, but he makes some mention, for example, when IBM sought review of a discovery order by a vindictive federal judge when he was clerking for Justice Warren Burger. A total of 6 petitions were filed, all denied, and rarely are any common law writs ever issued by the Supreme Court, but there are nonetheless multiple ways to offer the Supreme Court an opportunity to forthwith review a conviction by a rogue court, as would be the case here. Now, the example he gives, he mentions it was a federal judge, not a state court judge. And I don't know if there's any precedent for what he's talking about, but these common law writs, I mean, it's certainly, and I don't know the answer to it, but it's certainly something that's worth pursuing, because going through, if he is convicted, going through the appellate process at the state level is not going to serve Trump's interests. I mean, there's little chance that that gets taken up before the election.
Right, and this is all about the election. I mean, that's why the prosecution was brought in the first place, because
Right.
Donald Trump was running for president. It never would have been brought if he wasn't running for president. We all know that. Yeah, I'm not saying it's impossible for the Supreme Court to take it up directly. It's just not normal, and I would not see the actual procedure here. It's a nice legal theory the person has, and I'm not, again, saying it's impossible, but I don't see the Supreme Court preempting the normal review process on a criminal conviction.
Let me ask you something else, and this was picked up by Greta Van Susteren. Is this right? And this was reported in Politico, so I don't know if the reporters got it wrong, but that the Judge Merchan instructed the jury that they need not unanimously agree on what predicate crime he committed in order to convict him on the other crimes?
Well, I don't think he's instructed the jury on anything yet. That's coming this morning, so we'll
Right.
find out. I think that's
Well, he's poised to
reported
instruct.
is he's going to.
Yeah.
And this is the problem with this case. Not just this case. When it's not live streamed, when it's not televised, when we can't watch it ourselves, we have to rely on what is coming out through media reporting. Sometimes it's accurate, sometimes it's not. So I would be very shocked if the judge were to instruct the jury they don't need to agree on what the actual crime is. That would be pretty shocking. You can't convict somebody because two people think it's one thing, three people think it's another thing,
Right.
four people think it's something else, and no, you don't have unanimity on what the actual underlying crime is or underlying acts that gave rise to the crime. But we'll find out when we actually see his instructions, and I hope they'll be released in writing. I hope we'll get to read them as opposed to just hear what Politico reports he said to the jury.
And I get it, but I mean, just so we're clear, that's unconstitutional. You have to get unanimity on the predicate crime.
Well, here, keep in mind what the criminal allegations are here, and part of the problem in this case is that it appears that even through the 5-hour closing argument, the prosecution was just figuring out what the actual crime is here. And so the crime that allowed them to evade the statute of limitations, apparently, based on what I've read from the closing arguments, is an attempt to violate, a books and records violation with the intent to violate state election law by hiding secrets from the public. There are multiple problems with that, which is paying somebody to be silent is actually not a crime. Okay, hiding things as a politician from the public leading up to an election is not a crime. So that's the bigger problem here. But yes, the jury will need to decide what the actual crime was, and that unanimously that Trump did it. They cannot have a situation where they just have a collective plurality of different crimes that were committed. No, whatever goes to the jury on the jury form and in the jury instructions, they have to agree upon unanimously. You can't have, a mixed verdict that ends up being a guilty verdict. And so if these reports are true, that the judge is going to instruct the jury that they do not need to unanimously agree what the crime actually was, then that's a major problem.
Oh, this is such a hot mess. So if he is found guilty, how would the judge throw him in jail? I mean, would he speed up his sentencing hearing so that he could get him in the clank, or do they just want to get him so that they could label him a convicted felon?
Well, the judge has a variety of possibilities here. The judge, if this were a less high-profile case, the judge could remand him to custody right away, not let him leave the courtroom. That would be unusual in most cases. Usually there's a period and a sentencing report and all of that. But it's a possibility. It would be odd if it happened here, but there's so many odd things about this case. So my guess is that the judge would then schedule, a probation report or whatever that department is in the state system, a sentencing report. There'd be sentencing recommendations from the prosecution and the defense, and this process would take a while. My guess is if there's a conviction this week, it could all be done before the election.
I wanted to get just one more thing on this. I mean, you don't have to get into the prediction business. The two lawyers on the jury and everybody's trying to figure out if the lawyer's going to facilitate a conviction or are they going to facilitate an actual sober assessment of what's alleged and the law and find that what so many people across the political spectrum and the legal community have said that you just didn't even come close to making the case. There's reasonable doubt everywhere, as one CNN legal analyst said yesterday. But in terms of the grounds for appeal, where would you? I mean, because there's a lot of discussion of the failures by the judge as well as the prosecutor's case in chief here. Where would you go based on the accounts in the press of what's transpired in court? What are obvious places that you would go to make an appeal for Trump if convicted?
Well, I mean, I think you start at the beginning, which is that the crime alleged here is not actually a crime, and that the legal theory that you can convert a misdemeanor into a felony and therefore avoid the statute of limitations based upon the normal First Amendment political activities of a candidate is fundamentally unfound. It's not actually a crime, and so that I think is the start. That there's actually no crime alleged here, and that the legal theory is faulty. Forget what the evidence was. Forget how the judge acted. Forget all of that stuff. This should have been thrown out before there was even a trial. So that's where they would start. That the entire foundation of the case is a faulty legal theory that is not essentially undermines the constitutional right of candidates to run for office. So you could now have candidates being prosecuted because they're doing what candidates always do, which is hiding the bad stuff and talking about the good stuff. Is that now a crime? And so that's where you start. And then you get into a whole lot of things that, prejudicial testimony that was brought in based on what was reported. A big chunk of this case were things that had nothing to do with the actual crime. I mean, let's remember, this is supposedly a books and records crime, okay? This is not a crime of being Donald Trump and winning the 2016 election. But that's what most of the trial or much of the trial was spent on. So, I mean, prejudicial testimony coming in, the judge, his various rulings on what, was allowed and not allowed to come into evidence. All of that is in play. And then if the jury instructions are as bad as Politico is reporting they're going to be, then that's another one. The prosecution, I mean, I think there was, I don't know if the defense moved for a mistrial, but they should have. Prosecution reportedly made a lot of statements in the closing argument that were highly prejudicial, such as talking about Trump's joke once when he talked about shooting somebody in the middle of Fifth Avenue. That was referred to during the closing arguments. There was an objection. The objection was sustained, which meaning upheld, but the jury heard it. I mean, it came in. This prosecution, so there's a million things that went wrong with this trial, starting from the foundation of it having a faulty legal theory as the basis for the entire case.
And then you have the gloat, the greatest liar of all time, Michael Cohen. I mean, the left is trying to spin it as if, he is a liar, but he didn't lie in this circumstance, when clearly he did.
Well, Cohen is the only thing tying Trump to any of this. It's Cohen's supposed, conversations with Trump, which tied Trump to these books and records. That's what's the crazy thing about this case, which is that you have a books and records violation. That's actually the underlying crime here, that they entered these on the books and records of Trump's organization as legal payments instead of, a settlement with Stormy Daniels and the other woman, McDougal. And so the question becomes, how did that influence the election? Well, the prosecution's case has been is that there was a big cover-up, and it went back to 2015, and it continued to 2018. Of course, the election was in 2016. So why are they allowed to introduce evidence of what happened in 2018? And the books and records, I don't think there's been evidence that's been reported. Of course, we're not in the courtroom, but that how did the books and record entries affect the election? That I don't think has been really presented evidence. What they're saying is that there was a settlement with Stormy Daniels, which was not illegal. People get paid all the time to keep their mouths shut. That's not illegal, and that influenced the election. But that's not the crime alleged here. The crime alleged here is the books and records entries. How did those entries affect the election? And I don't think there's been any evidence of that, at least not reported by the media that's in the courtroom. How did putting it one way on the books and records versus another way on the books and records impact the election? And that's what hasn't been proven according to what, has come out of the courtroom. Instead, they spent the whole time talking about the settlement with Stormy Daniels and Trump's, alleged affair with Stormy Daniels and all that sort of stuff, which happened years earlier. This whole thing is a farce. It really is. And it's really, we talk about all the time the damage this is doing to our justice system. I mean, you're going to have at least half the country who absolutely believes our justice system, is shot. It's been politicized beyond belief. And even the half of the country that doesn't support Trump, you're going to have a big percentage of them who will understand that what happened here is wrong and the weaponization of the prosecution is wrong. When you even have commentators on MSNBC and CNN and, people who lean left, people who hate Trump, saying that this is very wrong what's happening. This is not normal what's happening. So you're going to have a majority of the country that believes that our justice system has been perverted for political purposes. And Team Biden sending people to hold press conferences outside the courtroom, Robert De Niro, is disgusting. I mean, if you needed any better proof that this is all political, then look at what happened yesterday with Biden campaign sending Robert De Niro to, mock Trump and mock the whole proceeding outside the courthouse. And Biden planning to give a public statement as soon as the verdict is announced. This is all political. Everybody knows it, and I really do hope it resounds to Trump's favor, because what's happened here is the prosecution of a non-crime because the person charged is a political candidate, and that shouldn't be happening.
Professor William Jacobson, clinical professor of law, director of the Securities Law Clinic at Cornell, founder of LegalInsurrection.com, and president of the Legal Insurrection Foundation, as well as the Equal Protection Project. Professor Jacobson, thank you as always.
Great, thank you.
Thank you. And he joined us on our turnkey.pro answer line.
The more you listen, the more you'll know. This is Chicago's Morning Answer. On AM 560. The Answer.
Gold and silver are at world record highs. The time to sell is now. PGS Gold and Coin is Chicagoland's #1 valuables dealer, specializing in rare coins and precious metals. PGS Gold and Coin Springtime Clean Out Buying Event. Grandma's jewelry box could be worth thousands. Mom's sterling silver flatware and tea sets could be worth thousands. Dad's coin collection could be worth thousands. Do not